Those are factual conclusions. Let me give you, let me give you, you agree, do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So, if we go back to Ms. Sildo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Ms.
Thank you, Chair. And then following that very same approach to all the concerns, I'm going to put it broad. Where in this affidavit do you find any grounds that can potentially get anywhere close to section 27B? And I put it that way because I'm talking to a lawyer of 30 years experience who appreciates that when a statute prescribes what jurisdictional factors must exist before certain outcomes are achieved, you would understand that they have to be satisfied independently of one another. It's first A, the suspicion, B, the grounds. Where in this affidavit do you find the grounds that would satisfy the requirements of section 27B?
I have referred to to those grounds and say that having heard what the chair has indicated, there's nothing more than just what he said here. It is a matter of, he says, this is what I have, information and documentation. I think the question, and sorry, Commissioners, I don't mean to be asking you all a question, but what I'm trying to pose for myself is, the question then is that sufficient for B?
Was there a sufficient factual substratum to satisfy B of section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of it, yes.
The factual basis that undergirds or supports the factual conclusion.
Correct.
You've accepted that there was none.
Yes.
Do you then accept on that basis, because my and your engagement has started on the basis of the first suspicion,
yes,
which is state capture, would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
his conclusions.
His conclusions of, I have information and I receive information and I also had information. It is on that basis, yes.
If that's where we land, would such an affidavit comply with the requirements of section 27? And what would be the consequences of non-compliance?
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes, On the basis thereof, Commissioners, I've applied my mind differently. The Commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes, I agreed that it fulfilled that requirement because he had knowledge. He had grounds on which it was based. I've given the answer, Commissioner. I can't change that answer.
Are you seriously telling us that since you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or
No.
IDEX legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No, I'm not going back on the argument.
Okay,
I'm saying
okay,
in the way I've applied my mind, this is a reasonable suspicion
Yes.
that must be borne by a reasonable man and a person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But Adams...
Once, you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law. criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
27. Yes.
over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that.
Yes.
Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the section 27 on the test of the reason.
Subjective, it must be.
At the time, yes.
It must be, because that's what you believed. Hence, your answers on a few good times now during this engagement, your answers that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So that means in your case, the word reasonable, which appears in so many words in section 27, did not come into the equation whatsoever. Is that so?
It does, because
no,
of
it
the
couldn't.
first
Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct.
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with the offenses, which was part A.
It's there fine and you are reading it fine. But what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said on your understanding the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Thank you, Chair. Based on the engagement you just had with the Chair, would it be a fair understanding that all your approaches to all Section 27 referrals you've had is the attitude you had to this particular one? So IDEC initiated investigations based on numerous of such affidavits which don't advance any grounds to support suspicions expressed therein. Has that been the case throughout the years you've been at IDEC?
No, ma'am.
And why then how have the other affidavits been dealt with? Have you interrogated their compliance with Section 27 before?